Estate planning for expats involve unique challenges and considerations because they often have assets, family, and legal ties in multiple countries. So here are key estate planning considerations for expats. First, understand the laws of multiple jurisdictions. Different countries have different rules on inheritance tax, probate, estate laws based on your residency and domicile status. So you want to be sure that you're aware of those differences. Some countries use what's called forced heirship rules, where an heir must inherit a set portion, which may conflict with your home country's wishes. Best practices is to have a will for each country. Seek estate planning tools to avoid probate or the equivalent in the US and abroad. Also, have your US documents apostilled and translated, and ensure that your US documents are coordinated with your foreign will or trust. So, this would involve creating multiple wills, multiple estate plans. So, your US will and trust will govern assets and distribution of your American based assets, including your financial accounts, your real estate, etc. This will follow US based rules and protocols. Then it's wise to have a foreign will or the equivalent in the country in which you are domiciled to govern the assets in that country. There must be clear coordination to ensure the wills do not contradict each other, and also include a pour over will, which will handle residual assets that you may accrue but may not have included in your estate plan. But it provides instructions of how to treat that property or that asset in the event it's not included in your current estate plans. So here's an example for you to think about. Say you're a US citizen and you live in Italy and you have assets in both the US and in Italy. Best practices is to have an estate plan respecting the laws of the US, handling your US assets, and to have an Italian estate plan. Your estate plan in Italy can elect for the law or the interpretation of the law of your nationality. So this lets you apply US law instead of Italian law, but only for the asset in Italy. So even though you're going to have an estate plan that's drafted compliant with the laws of the Italian laws, you can elect to treat the asset based on US law. But this must be written into your estate plan in Italy, that your selection explicitly states this in your will, that you wish to have US law interpreted and read in order to govern how you want your asset to be distributed. If you do not make this election, Italian law has forced heirship rules, meaning they have to apply what their law is regarding inheritance in their country. So say that you are a US citizen and you have assets in the US and you have assets in Italy. You have drafted a will respective of the laws of the US so that your property goes to two of your children. You only have two children. And 50-50 shares, you make sure that your estate plan allows for it to go to both of your children in equal shares in the US. Now, you have this property in Italy. How is this going to be treated? Especially because one of your sons helped you purchase this villa in Tuscany, let's say. So you want to have special provisions that allow that upon your passing, that the asset goes to this one son that helped you purchase this property, not to both of your children. Well, in the US, there's something called joint tenancy with right of the survivorship. This type of this type of co-ownership means that once one of the co-owners passes away, their share gets absorbed by the surviving shareholder. And in essence, that 50-50 now gets absorbed by the one who survives and bypasses probate. But in Italy, this concept is not recognized. Co-ownership simply means 50-50. Your half must pass through succession, meaning to your heirs. And so that 50% in Italy, unless otherwise indicated, will pass to your son. But this is not what you want to happen. So what you would have to do is draft an Italian situs will or a separate US will that explicitly elects US law to govern succession for your Italian assets. So the will must clearly state that your share of the Italian property goes entirely to your son in Italy that helped you purchase your property. Otherwise, failure to make this indication, your share will pass through succession to the other son. So this is why I emphasize that if you own property and have assets in different jurisdictions, that your US estate plan is insufficient in most cases to be dealt with in the foreign territory. And that's why best practices is to meet with an estate planning attorney in your foreign country to make sure that you draft an estate plan that is compliant regarding the laws of the land. Because otherwise, if you do not, the jurisdiction where you are residing is forced to apply whatever inheritance law exists. And so that might be an outcome that you do not want to see happen. And that's what's so creative about dealing with assets in different jurisdictions is that you can elect that your will be interpreted based on the law of your nationality to govern your Italian property. And so Italian authorities will apply US succession rules, and there will be no forced heirship to your Italian property. This is a powerful tool, but it must be very clear and prepared with a notary and cross border lawyer. So, what would this look like? Here's an example. Anna, a US citizen, moved to Florence 10 years ago. She and her daughter Sophia decided to buy a small Tuscan home together as co owners, each paying for half. The deed shows each of them owning as 50% owner. Anna has a son, Michael, who lives in the United States and does not have any involvement with the property. So, Anna's goal, she must explicitly state in her will, when I die, I want Sophia to have the entire house because she bought it with me. It wouldn't be fair for Michael to inherit it. So the problem is that Anna assumes that just because she has a US will saying my share of the Italian house goes to Sophia, that that's enough. However, in Italy, forced heirship rules automatically apply. So at Anna's death, her 50% share is divided between both children, regardless of what her will says. Without planning, Michael could legally claim part of the Italian home. This could force Sophia to either buy him out or sell the property. So the solution would be drafting an Italian situs will specifically covering her Italian asset. Choose US law to govern the asset. This allows her to opt out of Italian forced heirship. So in the will, it will clearly state that her entire 50% share of the Tuscan home goes to Sophia. The will was registered with the Italian notary, so will be recognized immediately upon death. Another consideration is that Anna could consider transferring her share to Sophia during her lifetime, which would completely remove the property from her estate when she passes away. However, after reviewing the tax implications, she preferred to keep ownership for now and rely on the will with US law election. So the lesson here is for US citizens owning property in Italy or any other country that forced heirship may apply, and this may result in an outcome that is undesirable for how you want your estate plan to be carried out. So make sure that you draft a will and that you include provision to have a choice of law. This is really crucial if you want your children to inherit smoothly. Also, think about trust. Does your new country recognize trust? Trust, revocable, irrevocable trust. There's several different types of trusts that are readily used in the US to avoid taxes, for Medicaid eligibility, to avoid probate. But in the new jurisdiction, the use of trust may be different or it may not be recognized. So the way they're used to manage assets across in the US may not be as readily available in the new jurisdiction. So if you have a trust in the US, you must structure your trust carefully to comply with laws of multiple jurisdictions. Again, some countries do not even recognize trust, so your foreign assets may need to be put into an LLC in order to fund the trust, which is a little more complicated. In terms of power of attorney and healthcare directives, power of attorney and healthcare directives are where you select a person, a trusted person, and an alternate person with the power of attorney for financial and medical decisions in your current country. So make sure you prepare these sorts of documents to make sure your desires are ironed out regarding who would this person be to stand in if you cannot advocate for yourself to conduct certain business, to perform certain transactions. So you want to make sure that you prepare in advance according to local laws. And again, this has to be prepared across different jurisdictions. Make sure that you iron out beneficiary designations, check and update. Retirement accounts, life insurance, investment accounts should have beneficiary designations updated and consistent with both of your estate plans. So, local versus international assets. Some assets bypass wills through direct beneficiary designation, so coordination is critical. If you're relocating with minor children, you want to nominate guardians in your will considering legal recognition across countries. So, what are your wishes for your children if you die while living abroad? In terms of language and documentation, wills and other documents in the US should be in the language recognized by the jurisdiction and possibly translated officially and apostle to ensure compliance and coordination of both sets of documents. Make sure the documents are accessible to a trusted person and professionals. Also, Whoever you select, trustees, executors across jurisdiction, speak to them and ensure they understand the implications they may be managing estates in different countries, as well as your guardians. If you have a trust in a country that recognizes trust, ensure what the requirements to be named as trustee are. But this involves coordination with specialists in that country. Also, be aware that in some countries, the trustee may have to be a citizen of that country. What is the workaround if the trustee is not a citizen? Then what happens? For example, the United Kingdom, there's no strict citizenship required for individual trustees, but trusts often require trustees who understand UK law, especially if the trust is a UK resident. So some regulated trusts require professional trustees, which may be a UK based company, not a person necessarily. In Singapore, for example, professional trustees must be licensed and based in Singapore and cannot be a US citizen who is unlicensed regarding Singaporean law. So, in summary, when you own assets in multiple jurisdictions, this involves coordination of different types of documents, including having estate plans in both jurisdictions. That's best practices. And that you want to make sure if you have special considerations in your foreign country, that you have explicit language in your foreign will that reads in US based law. You also want to coordinate with your executors, your personal representatives, your trustees, your guardians to make sure that they're aware that they may be dealing with assets in multiple jurisdictions, especially if you have small children, that there are additional considerations that they have to apply if they're the guardian. You also want to make sure that you're regularly checking and reviewing your beneficiary designation to bypass probate, not only in the US, but the probate equivalent in the foreign jurisdiction. With moving abroad, this is a major life decision. So you want to make sure you're reviewing your estate planning documents regarding this major life decision. And make sure you meet with an estate planning attorney in your foreign country to ensure compliance. And you also want to coordinate with your documents. Make sure that they are translated, they are apostilled, and they're coordinated well with your foreign will. So those are best practices working with estate planning attorneys, lawyers, tax advisors that are experienced in international and expat issues, creating your US based documents that are compliant with the laws of your new country.